different notes on this issue. In order to understand the problem of judicial accountability, or really the problem of corruption in the judiciary today, we need to have a clear understanding of what has made or what has led to this degree of corruption in the judiciary, where we have been forced, as Justice Verma also pointed out. Somebody asked him, who were the honest Chief Justices after you? Now, we have been forced to say that half of the last 16, 17 Chief Justices were corrupt, very reluctantly. Now, why has the situation reached this path, where at the very highest level of judiciary, this is the state of corruption? I think in order to understand that, we need to understand what are the incentives in the system for corruption, what are the disincentives in the system for corruption, which allow a judge to become corrupt or remain corrupt. Incentives are, of course, created by the kind of litigation that is going on in the courts today, by the sheer amount. I mean, one case like this Reliance gas disputes case involved stakes of lakhs of crores. I mean, on the decision of the court turned lakhs of crores, whether few lakh crores would come to industry A or company A or go to company B. So the sheer amount of stakes involved in litigation in the courts today give rise to huge incentives for corruption. On the other hand, what are the disincentives? Disincentives are created by accountability systems and institutions which check that if you indulge in corruption, then you will be caught, held accountable, brought to book. Today, we have a situation where enormous incentives have been created, but there is no check whatsoever on corruption within the judiciary. And why do I say that? First, there is no disciplinary authority over the higher judiciary. The only thing that you can do to a sitting judge is to impeach him, and that impeachment we have seen from the case of Ramaswamy, from various other attempts that we have made, is virtually a totally impractical process. It is impractical for several reasons. First, you need to get signatures of 100 MPs of the Lok Sabha or 50 MPs of the Raj Sabha. MPs are of political parties, all of whom have important cases pending in all the courts. If you are impeaching or seeking to impeach a Chief Justice of a High Court or a Judge of the Supreme Court, political parties are extremely reluctant. We have seen that. Extremely reluctant to sign an impeachment motion unless two conditions are satisfied. First, you must have documentary evidence of very serious misconduct. Documentary evidence. Second, that it must have become a public scandal. Mere fact that you have documentary evidence is not sufficient to persuade political parties to sign an impeachment motion against a powerful judge, that is a judge of the Supreme Court or a Chief Justice of a High Court. We have seen that from experience. Not one case, large number of cases. I can tell you, we have ourselves prepared with full documentary evidence impeachment motions against several judges of the Supreme Court, several Chief Justices of the High Court, but we have found in every case, unless, like in the case of Ramaswamy or in the case of Dinakaran, where the matter became a public scandal, where enormous media publicity was given to the scandal accompanying it, only then and only then do the political parties agree to sign impeachment motions. So therefore, and moreover, even if you succeed in getting it signed by the requisite number of MPs, as we saw in the case of V. Ramaswamy, it is capable of being politicized right at the end during voting, where the entire ruling party at that time, the Congress party, abstained, passed a whip asking all its members to abstain from voting because he developed some political connections or he had some political connections with the ruling party. So therefore, this impeachment is a totally impractical, unworkable process. And that is why we need an effective institution or an effective mechanism to whom complaints can be made for misconduct or corruption against a judge and who can independently, credibly and properly scrutinize those complaints and take action against that judge. Unless you have any such mechanism, the judges of the superior courts feel that, well, stakes are lakhs of crores, I am being offered 100 crores, I am being offered 100 crores in a Swiss bank, well, why should I not take it? What can be done against me? Nobody can do anything against me, nothing can happen to me, and therefore this creates, there is no check, no disincentive against accepting this money. Temptations are huge and therefore they accept it, and that is why we need an effective institutional mechanism. The second problem of judicial accountability, or rather lack of it, is that the Veeraswamy judgment which Justice Bhavan referred to. That judgment has provided that even an FIR cannot be registered against a judge, against a sitting judge of the High Court or the Supreme Court without the prior written consent of the Chief Justice of India. Now, in this case, the earlier Chief Justice, even in the case of Justice Yadav, he refused permission for charge sheet of Justice Yadav. Only when the present Chief Justice came into office that this permission has been given. We have written repeatedly, not once, in many cases against many judges, against Justice Bhalla, against Justice Vijayendra Jain, against many other judges to earlier Chief Justices, seeking their permission to register FIRs against them on the basis of hard documentary evidence. And these were not complaints made by any Tom, Dick or Harry. These were complaints made by the Committee on Judicial Accountability, signed by several former Chief Justices of the High Court and several other responsible senior advocates, former law ministers, etc. But yet, these complaints were totally ignored, thrown into the waste paper basket for various reasons. For the reason that the then Chief Justices, etc. had some connections, friendship, etc. with the judges against whom complaints had been made. So, that's the second problem. The third problem is contempt. Even if you expose a judge, like Midday did expose Justice Agarwal, who had retired by that time, and yet you run the risk of corruption. They exposed him with full documentary evidence. They showed with documents published in the newspaper. They took the plea of truth, even after truth had been made a defense, and yet they were sentenced for 4 months imprisonment. Arundhati Roy merely said in her affidavit that for the Supreme Court to have issued contempt notice on such a frivolous petition shows a disquieting inclination on the part of the Supreme Court to muzzle criticism and silence dissent. On that she was held guilty of contempt and sentenced to jail, and by the very same judge against whom her criticism has been directed. So therefore, that we have been saying for a long time, it is not enough to make truth a defense. There is absolutely no reason whatsoever for scandalizing the court or lowering the authority of the court to remain in the definition of criminal contempt. It is said by judges that no, if you remove this thing, all kinds of allegations will be made, the whole integrity of the institution will come crumbling down, no authority will be left with the judiciary. Totally wrong perception, totally wrong reasons being given. After all, does the power of contempt vest with the executive? Does it vest with the Prime Minister? Does it mean that if there is an honest Prime Minister, people can still make any kinds of bogus allegations against the Prime Minister and his authority and his integrity will come crumbling down? A judge's integrity is judged on the basis of his actions, not on the basis of any ridiculous complaint that some some disgruntled litigant might make, people can make out whether there is any substance in this complaint or not, whether the complaint or whether the allegation is backed by some evidence or not. Any allegation is not going to bring down the reputation of an honest judge. Reputations are built over a number of years on the basis of your actions. So therefore, there is no justification for this scandalizing the court or lowering the authority of the court to persist in the Contempt of Court Act. It is not there in the US. In the US, the only test is clear and present danger to the administration of justice. And that is already there in the Contempt of Court Act where it says any interference with the administration of justice. So if you threaten a judge, threaten a witness, threaten a lawyer, if you go and disturb the court proceeding, that is interference with the administration of justice. That can certainly and should certainly be contempt, but there is absolutely no justification for this to persist. The effect that this is having is that it is deterring the media, particularly the media. It is deterring the common people of this country and the media from exposing corrupt judges even if they have evidence to show that this judge has indulged in corruption. The fourth problem of accountability is that even under the Right to Information Act, the judiciary is shying away from the implementation of the Right to Information Act to the judiciary. In the case of disclosure of assets, in the case of disclosure of correspondence on appointment of judges, Central Information Commission ordered that this information must be disclosed, and they used the Supreme Court's own judgment, 7 judges' judgment in S.P. Gupta's case, which says so repeatedly over 30 pages as to why this correspondence must be disclosed to the public. Correspondence, and they put it precisely on the Right to Information, even at a time when the Right to Information Act was not there. Despite that judgment, which is completely binding, 7 judges' judgment, the Supreme Court files appeals against the orders of the Central Information Commission, against the orders of the High Court, directly to itself, stays the order of the High Court, of the Central Information Commission and of the High Court, and refers the matter to a constitution bench which will remain pending for the next 20 years. For 20 years, for the next 20 years, no information is being given about the judiciary, about appointments. All these appointments that are being made are shrouded in complete mystery. Nobody has any clue as to on what basis, on what consideration, who said what are these appointments being made. No criteria has been laid down for appointments. No system has been provided for appointment. It's a completely ad hoc process which has been adopted of collegiums, etc., which has resulted in all kinds of these kinds of people being appointed, where one has to say that half of the last 16, 17 chief justices have been corrupt. So this is the state of affairs, and that is why there is a very, very serious, exceedingly serious problem of lack of judicial accountability. Today we have a higher judiciary which enjoys enormous power. They can strike down executive acts, they can strike down government policy on the ground of arbitrariness, mala fide, they can strike down laws made by parliament, they can even strike down constitutional amendments. Today the judiciary is the most powerful institution of the state, but it is an institution which is totally unaccountable. It's a situation which is tailor-made for corruption, and that's what has been happening, unfortunately. Now the problem, this bill has all kinds of problems. I agree with Mr. Nariman, though not for the reason given by him, that this bill needs to be scrapped. First problem, it says that when a complaint, it formulates 2 kinds of committees, an oversight committee and a scrutiny committee. Oversight committee consists of a retired Chief Justice to be selected by the government in consultation with the Chief Justice of India, 2 sitting judges of the Supreme Court to be selected, 1 sitting judge of the Supreme Court, 1 sitting Chief Justice of a High Court to be appointed by the government in consultation with the Chief Justice of India, the Attorney General of India, and another person to be nominated by the government. So 5-member Oversight Committee. The job of the Oversight Committee is to receive complaints and refer them. If they find that there is any prima facie substance, then they refer them to the Scrutiny Committee. Scrutiny Committee consists of the Chief Justice and 2 judges. A former Chief Justice and 2 judges of sitting judges of the same High Court or the same Supreme Court. Now, and they will go into the complaint and see whether there is any material, any good material. If there is good material, then they report back to the Oversight Committee. Oversight Committee then appoints an investigating committee, which is like the Inquiry Committee under the Judges Inquiry Act, which holds these inquiry proceedings, and then that Inquiry Committee holds virtually a trial of the judge, gives a report. If they hold the judge guilty, then the matter goes back to the Oversight Committee. If the Oversight Committee feels that the judge needs to be removed, then they recommend the same to the government. Then the government has to bring an impeachment motion in Parliament, and then the matter goes through. Simultaneously, the bill provides that all proceedings, the complaints will be kept secret. Nothing about the complaint will be revealed to anybody. All proceedings will be held in camera. If the complainant divulges anything about his complaint or about the evidence with his complaint to anybody, he will be sent to jail. If the complaint is found frivolous or vexatious, he can be sent to jail for 5 years. These are the various other relevant provisions in this bill. Now my criticism of this is as follows. Firstly, the Scrutiny Committee consists of 2 judges of the same court, a retired Chief Justice of the same court. One of the problems that we found even in the Justice Dinakaran inquiry was about a judge who had been sitting with him, with Justice Dinakaran, for just 5 years in the same court. And being a colleague, you have participated in a number of division benches. You have participated, you have met in innumerable social occasions. You sit inside court, outside court with the same person all the time. Even if you are a very objective person, I say even if you are a very objective person, I would feel very diffident. I mean, even if I were in that position, where a complaint against a professional colleague with whom I have been sitting in court, out of court on a daily basis for years altogether comes to me, I would feel very, very constrained. I will not be able to objectively exercise my judgment in the matter, because all kinds of embarrassment, etc. comes in. And that is why we have been saying that the judicial complaints, we have been saying in fact that there should be just one judicial complaint commission. We have been saying that it should consist of 5 people. You can appoint them, and those 5 people should be full-time people, not part-time. One of the problems that we have seen in even the proceedings under the Judicial Inquiry Act is you have a sitting judge of the Supreme Court, you have a sitting Chief Justice of the High Court. These are people who have their plate full with their judicial duties. They don't, if they have to take time off to spend time in the inquiry proceedings, they have to disturb their judicial work. And that is why we have been saying this is a matter which requires a full-time body, which has to be independent of the government and independent of the judiciary also. It has to be a completely independent body which has no conflict of interest. With the government, if it is under the government, there is a conflict of interest because it compromises the independence of the judiciary. If it is a body controlled or essentially manned by the judiciary, There are other conflicts of interest that you are deciding against your own professional colleagues, etc., with friends of yours, and therefore we have been saying that it has to be a completely independent body. We have suggested a method where we have said you have a chairman who is appointed by all the judges of the Supreme Court, a second member appointed by all the Chief Justices of the High Court, but they have to be full-time members. A third person appointed by the Union Cabinet. A fourth person appointed by a committee of Leader of Opposition in the Lok Sabha, Leader of Opposition in the Raj Sabha, Vice President and Speaker. And a fifth person appointed by a committee of Chairman NHRC, Chief Election Commissioner, Comptroller and Auditor General, Chief Vigilance Commissioner, etc. So you have 5 members appointed in this manner by 5 different committees. And the method of selection by those committees should be transparent. In the Lokpal bill that we have prepared a system of transparency. We have suggested a system of transparency in the appointment of Lokpal. We have said that you first prepare a criteria on the basis of which you will be selecting the Lokpal. Same thing can be done here. What are the qualities that you are looking for? Then you advertise this and allow the members or any member of the public to suggest or nominate people with whatever evidence that they have that this person amply fulfills this criteria or satisfies this criteria. From those, the selection committee prepares a short list of 3 times the number of people who are to be selected. When that short list is then again put up in a public website and comments are again invited from the people. Once those comments come, information, evidence, whatever, Thomas would never have been appointed if this kind of procedure had been followed. Once those comments come, then you send the matter, take all that evidence and those comments, information to the selection committee, and thereafter the selection committee meets and makes its decision. And all these things are put on a public website so that people can see how the selection is being made. The most important thing in ensuring that people are being properly selected is broad-basing the selection process and having transparency in the selection process. Today what we are seeing is that there is neither any transparency nor any broad-basing in this. And then there is this problem in the bill about in-camera proceedings. If this is going to be the committee and the proceedings are going to be in camera, then the problem is that people like me, etc., will have no confidence that normally people have no confidence that this matter is going to be objectively decided, because you are sending it to a scrutiny committee consisting of brother judges of that same judge, professional colleagues of that same judge, and therefore, and if we know that this matter is going to, as soon as we make a complaint before this committee, the whole thing goes under camera, in camera, and there can't be any transparency. I cannot release this information to anybody or to the media, etc. Then I will never send any complaint to this body. I think that a much better sanction is to expose it in the public. Once it is exposed in the public, once sufficient pressure is built up by public exposure, etc., then only I have found that the authority acts. That is unfortunately what has been happening by and large. I mean, barring exceptional cases, of course we have today a very fine Chief Justice who is very, very concerned about integrity, etc. Justice Verma was there. There have been such Chief Justices and such judges. But by and large what we have found is, by and large our experience has not been good. And therefore, we cannot trust this process unless there is transparency in this process. If you are going to say that once you put your complaint in the system, then the whole thing goes under wraps, then I would rather not do that. I would rather say that, well, let it go in the public and we'll see what happens if the public pressure results in some action Well and good. So therefore, we need this bill, as I said, is of no use because it is proposing committees which are neither independent of the government. Attorney General is not independent of the government. Attorney General is not even independent of the judges. He is practicing before the same judges day in and day out. Suppose there is a complaint against a Supreme Court judge. What will the Attorney General be able to do? Barring a very robust Attorney General who is not afraid, by and large, Attorney Generals will not be able to independently exercise their judgment when it comes to complaints against judges before whom he is practicing every day. And then there is a nominee of the government. So you have a committee which suffers from the worst of both worlds. It is neither independent of the government nor independent of the judiciary. You have three people from the judiciary, even a former Chief Justice. There may be some very outstanding former Chief Justices who are very objective, etc. But suppose the person against whom the complaint has come is a person whom he has himself appointed. As Chief Justice, he has participated in the appointment of several judges. He has recommended the names of several judges and the complaint comes against that same judge. What happens? So, therefore, my feeling is that this body which takes up complaints against judges and decides what to do with those judges must be a body which is completely independent of the government and completely independent of the judiciary as well. But even if you have retired judges in that, it must be ensured that those retired judges will not deal with the case of judges with whom they have been professional colleagues in any court or with whom about whose appointment they may have participated in their selection process. That has to be ensured in any case if this kind of body is to have any credibility or any kind of effect whatsoever. So these are broadly my views on the matter. Thank you very much.
Thank you, Prashant. Before I put it for the discussion, rather for some